Good morning, everyone. Welcome to our on-site Summer Update 2023. Before we get started, there are a couple of housekeeping notes. Participant video and audio have been disabled to minimize disruption. If you would like to pose a question or comment to any of our presenters, please use the Q&A function, and we will either write a reply or respond during the Q&A session. Alternatively, you can email the speakers direct following the event. Following the webinar, we will send a short feedback form. Please take 2 minutes to complete it. Your feedback is really important to us and helps us adapt future events and topics to your needs and wishes. The webinar will be recorded and posted to our YouTube channel next week. You can also find the recording of our previous episode on the channel. Now, today we have 4 very interesting presentations. First of all, we have Final Accounts in Construction Projects. Are they too little, too late? And that's by Ryland Dispute Resolution Partner at WFW. Then we have Don't Overlook Legal Nuisance by Desai Dispute Resolution at WFW. Then we have Who Pays for Fire Safety Repairs by Barry Hembling, Construction Partner at WFW. And last but not least, we have Where Are We Going with Construction Price Inflation by Alistair Wardle, Divisional Director at Stace LLP. So without further ado, I will hand over to Ryland.
Thank you very much, Teresa, and good morning, everybody. So the topic of my talk is final accounts in construction projects. Are they too little, too late? I thought I'd start by mentioning Arsenal Football Club and say that clearly it was too little, too late for them, having been pipped at the post by Manchester City doing the treble. And then West Ham, of course, winning a European Cup. Who would have thought that happened? But back to construction. First of all, I think we should start with the legal framework. And I think this is very interesting in terms of the split of obligations. First of all, if we look at the common law position, in construction contracts, you'll see that there's a right to payment in relation to completed works. Now, that means that at common law, you don't get paid for your work until it's all complete. Now, this is obviously an old principle. If we look at the cases here, we've got Cutter and Powell from 1795. Which is a good old case involving a second mate on a ship who was due to be paid at the end of his voyage. And unfortunately, he died partway through, and his widowed wife tried to seek payment. And the court said, no, he didn't make it, and therefore he doesn't get paid. That was followed several years later. We then get to sort of 1887, where the court started to say, well, actually, you can also have provisions in contracts that say that there's a condition precedent to payment in relation to the value of works. But in that case, the court did say, if you don't meet the specification in the contract, then you're not entitled to be paid the value that had been agreed. And you can start to see a development of more detailed provisions and judgments in relation to construction projects. But we should remember that there's earlier cases, and indeed cases that follow that do say that substantial completion in some cases can be enough. In other words, the courts now accept that you can have a payment where not all of the works are complete. You can get paid when they're substantially complete, or of course when they're practically complete. Which is a definition and a concept that's been developed in a number of standard forms of contract, which I'll come back to later. That's the common law position. However, in construction contracts, you've got the Construction Act, which clearly sets out statutory right to be paid interim payments, and that should be on a regular basis. So we've got that under section 109, and then we've got under 110, a requirement for an adequate mechanism for payment, which means you need to be able to determine the due date and the final date for payment in relation to each payment. And I thought it'd be worth mentioning this recent case of JSM, where the courts decided that that doesn't mean you have to have a final account provision. So moving on, once we look at the legal framework, the next question is, how do we operate interim versus final account provisions? Now, if we look at the statutory provisions, they talk about, in relation to interim payments, the notified sum. In other words, there's no investigation into the merits of that value. And in fact, there's an obligation to pay that notified sum, even if the figure is wrong, even if that figure represents too much or too little. And so parties can get caught out in interim payments by having to effectively overpay, or indeed where they get underpaid for works, depending on what the notified sum is rather than the true value. Now, we must also remember that within standard forms of contract that are often amended, there are provisions that allow for a pay less notice to be issued by the payer, which means that they can adjust the amount payable. However, it's important to note that most standard forms of contract do not include provisions that allow for repayment of previous overpayments in relation to interim sums. And that's a big super black hole, I think, in the provisions of those contracts. So moving on to the next slide, let's look at the JCT design and build contract in relation to final payments now. Now, the final payment concept under these standard forms is a lot more complex. It's not about the notified sum. There are a number of prerequisites that have to happen prior to that amount being assessed. So if we look at clause 424(5), the due date for payment is 1 month after the last of the following: the end of the rectification period, which comes after practical completion, normally 12 months, but it can be agreed a different period applies. And the second point, the date stated in the notice of completion of making good, which comes after the rectification period and after the rectification of defects, which may never happen. And then finally, the date of submission to the other side of a final statement, that is to say, where you don't receive one. So you can see that that's a convoluted process, and I can tell you from experience that very few parties actually follow that procedure correctly. And then you get to the final date for payment, which is 14 days after the due date. Well, there may be a dispute about whether the due date's actually even occurred if we don't know whether practical completion has arisen. There's a dispute over practical completion, and any one of those notices above haven't been issued. If we compare that with the NEC contract, the new engineering contract, under 53(1, the project manager assesses the final amount due 4 weeks after the defect certificate, which is much like certificate making good, or 13 weeks after any termination certificate is issued. Now, that's a useful comparison because it talks about termination, whereas, of course, the JCT final account provision doesn't. But the JCT provision does have, in relation to termination, payment provisions of its own. But that's in a different section of the contract in clause 8. So you need to be aware that there are different mechanisms depending on whether there's been termination or not, and there are often not consistencies between the different forms of contract. Moving on to the next slide, you'll see that under the FIDIC contract, for example, you can have partially agreed final statements, which of course leaves the question open as to how you assess the elements of the account that have not been agreed, and indeed when the final payment should be made in that regard. So overall, we can see that we've got a very streamlined, simple, functional mechanism for interim payments. And in respect of final accounts and final statements under standard forms of contract, the provisions are convoluted and often cause delay in the settlement of final accounts. So in terms of the practicalities, how can we overcome these problems? Well, first of all, the most common issue is that there are disputes around practical completion. Now, the leading case in relation to the definition of practical completion is Mears and Cospan, which is a case that I was involved in and successfully run arguments in both the High Court and the Court of Appeal. And it was the first judgment on practical completion for 50 years. But what the Court of Appeal decided essentially is that practical completion is easier to recognise than define, which is not particularly helpful. But what they also said was that practical completion can be achieved where there are de minimis, minor defects, and indeed defects that cannot be remedied in some cases can even be acceptable. And that was the situation in that case where certain rooms weren't built in accordance with the drawings, but that didn't matter because the building could still be used. So definition of practical completion is key in the contract to answer the question as to whether you've achieved it. The other issues are about making good defects after practical completion has been achieved. And I think documentary evidence is the key point here, making sure that you've got good records to demonstrate that you've achieved practical completion, or indeed insisting on those records being provided. The other issue is you've got delay claims and extension of time claims and loss and expense claims that result from those delays. And often contractors will wait until the end of a project or towards the end to bring those claims. And I think that's an issue that needs to be addressed head on in relation to interim payments. So in summary, final payments can be delayed significantly for a number of reasons, causing financial stress on the contractors and subcontractors, but also creating expensive ongoing disputes for employers having to deal with legacy issues. In conclusion, really, most standard forms are, in my opinion, not fit for purpose. They need to be amended. Interim payments need to be based upon the merits. We need to have readjustment provisions in relation to interim payments to look at the quality of the work, but that requires mechanisms, it requires professional input and assessments to be made on a regular basis. I suggest here that actually what we could use is more technology and even the dreaded AI potentially telling us what the value of works are, or at least making recommendations based upon data sets. And this is an example, I think, where technology can be a help more than a hindrance and relieve some pressure and allow parties to comply with the provisions of the contract. Final account provisions need to be fair and simple, and of course, they need to make sure that they deal with the due date and the final date in a timely manner. I'm going to pass now on to Deb Desai. Thank you very much for listening.
Thank you, Ryland. In my slot, I'm going to talk to you about the two buildings that you can see in the foreground of this image and how they've created a new legal issue that developers and landowners should be aware of. In 2012, the Grosvenor Estate and Native Land constructed Neo Bankside, an apartment block in the South Bank in London. Some 4 years later, the Tate Modern completed an extension of its art gallery some 34 meters away. It was named the Blavatnik Building in recognition of a £50 million donation from the Ukrainian natural resources tycoon. The top story of the Blavatnik Building was open to museum patrons as a viewing gallery. As you can hopefully see in this photo, it was open on all sides and so offered windowless views in every direction. In one of those directions stood the Neo Bankside building. It'd been constructed with curtain walls, that is, walls comprising mostly of glass. This meant that the interiors of the residences on the 13th to the 21st floors could be readily seen from the Tate's viewing gallery. Indeed, residents sometimes found pictures of their dining rooms and their living rooms on social media, posted by visitors to the Tate Modern. For obvious privacy and copyright reasons, I'm not going to be putting those photos up. So, some of the Neo Bankside residents sued the trustees of the Tate Modern, claiming that this intrusion was a nuisance. But what is a nuisance? Well, a nuisance is the wrongful and substantial interference with the ordinary use and enjoyment of one's land. What amounts to wrongful interference or ordinary use is determined by looking at the character of that particular locality. Now, the law of nuisance protects some common issues, noise, fumes, and vibrations. But what you'll notice is that list does not include overlooking. It's well-established law that merely overlooking another property does not give rise to liability and nuisance. To the surprise of many lawyers, the case went all the way to the Supreme Court and the Neo Bankside residents won. The judgment explained that a viewing gallery open to the public was not an ordinary use of a building in the South Bank. The reciprocity rule of give and take that would ordinarily protect parties using their premises as they wish did not extend to protect the Tate Modern from a claim. The court thought that it would be unreasonable to burden the apartment owners who you'll remember chose to live in homes made of glass walls with the responsibility of mitigating the impact of the Tate Modern's unusual use of its land by, say, putting up curtains. The court said that the law of nuisance still does not protect against mere overlooking, but it does protect against intense and constant visual intrusion. The Tate Modern has closed the viewing gallery facing the Neo Bankside pending negotiations or another hearing at which it will be decided whether there should be an injunction or damages. As you can probably tell, I have a few difficulties with this decision. The courts drew parallels with a wonderful case from 1341. Incidentally, Ryland only managed to refer to a case from 1795, I think, and so I win the prize for legal antiquity. Anyway, in my 14th century case, a fishmonger by the name of John Le Lécher constructed a watchtower on his land so that he and his family could sit and watch his neighbor's household, much like a modern-day soap opera. The court didn't have much trouble deciding that that was a legal nuisance. However, this ignores a couple of key distinctions. Even in that medieval setting, a watchtower was an obviously unreasonable use of land. Moreover, the tower only served the very deliberate purpose of spying on the neighbor's residence. However, in the locality of the Tate Modern, where you've got the likes of the London Eye or the Shard in the vicinity, is another tourist viewing platform offering panoramic views in all directions really that an exceptional use of land? In the Australian case of Victoria Park Racing in Taylor, the racecourse claimant lost in a case against a neighbour who had installed a broadcasting tower on his land, thereby diverting and building a competing betting business. The court refused to treat the tower as a nuisance, saying, the law cannot, by an injunction, in effect, erect fences which the plaintiff is not prepared to provide. I find those words echoing in my head when I think that commonplace furnishings, which effortlessly protect domestic privacy, do exist. The Neo Bankside apartments all came with pre-installed blinds. I would think that most households in the UK use net curtains. Good quality privacy film is readily available in the market. As a matter of principle, if the law is to balance the uses of nearby premises to maintain civil neighborhood relations, should we not be examining the manner of the claimant and the defendant's uses? Anyway, whilst I would love for you to create a case in which I can test my legal theory, for your sake, I think you're better off avoiding the nuisance of visual intrusion. How? Well, if you're building in a confined urban environment and your development plans incorporate features such as a rooftop bar or gardens, terraces, of course, a viewing platform, you should get legal advice. I think in the same way that you'd protect yourself against rights to light claims if you're building say, something which would interfere with the natural light to neighboring buildings. I have a few thoughts about possible workarounds and mitigation approaches there. The other thing is, I think it would be dangerous to rely on the planning system to resolve this issue. Of course, both of these buildings in these cases have planning permission. Securing planning is no protection against a claim for nuisance. The wider takeaway for me as a lawyer is that this Supreme Court decision reminds me that courts will extend the law of nuisance to cover relatively novel situations, just as they did back in 1341 with Mr. Leleche. I can't leave you to a slide of text, so here's a photo I took from Sushi Samba at the top of the Heron Tower in London. I'll let you decide if this is mere overlooking or risk the tort of nuisance due to visual intrusion. That's all from me. Let me pass you over to Barry, who's going to be talking to you about something that keeps us property and construction dispute resolution lawyers very busy at the moment: the recoverability as between landlords and tenants of the cost of construction remediation of defects of external wall systems. Thank you.
Thanks very much, Dev. Ever since the Code of Hammurabi in 1792 BC, there have been regulations regarding construction law and the remedying of defects. And we've seen the latest in the UK of a series of regulations published this week. Those regulations were published under the Building Safety Act 2022. And those regulations are intended to protect leaseholders from fire safety related repair costs following the tragedy of the Grenfell Tower fire. Now, as the Act was going through Parliament, there were a series of last-minute amendments to the bill, and the amendments resulted in a situation where some leaseholders pay nothing for remediation costs, others pay a limited amount, and other leaseholders may not pay anything at all. And there's also amendments that were made quite late, which required certain contributions from landlords in limited circumstances. So the position has become quite complicated within a very short period of time since the Act was passed last year. And so I want to unwrap some of the issues in this talk by exploring who pays for fire safety related remediation works. So first of all, in order to look at the issue, you need to go through various criteria. So in the next slide, I've identified, first of all, some of the criteria relating to buildings. So we're talking about buildings that are over 18 meters, of at least 2 residential units, and that are self-contained buildings. Then there's a whole series of criteria concerning qualifying leases. And generally that relates to leases that are over 21 years, comprise a single dwelling, that attract a service charge liability, that were granted before the 14th of February 2022, and don't fall within the series of exceptions. So there are a number of exceptions under the Act, such as social housing tenancies, which have their own regime. It's then necessary to look at the works and the defects. So first of all, in terms of the relevant defects, was it a defect that causes a risk to safety of people in or about the building that arises from the spread of fire or the collapse of the building? In terms of the relevant works, did the works result from the construction or conversion of a building for residential use? And there's also a time period when the works need to be carried out in order for the various provisions of the Act to apply. So the key period is between June 1992 and June 2022. And the relevant time period is 14 February 2022. So that's a key period that runs throughout the Act. And the Act keeps coming back to that date, which is the relevant assessment date for so many of the provisions as to whether protections are provided for the costs of remedying defects under the service charge. So within those parameters, we also look at the relationship between the parties. So, you know, we need to understand whether the landlord and the developer are the same party. We need to look at whether the landlord was in a group of companies that may have been linked to the developer of the defective building. And we also need to understand whether the current landlord, assessed at 14 February 2022, was part of a partnership or a joint venture that may have developed the building that's now unsafe. So there are effectively the rules within which the Act operates. And there are various scenarios that arise from those criteria and that I will now look at very briefly in order to explore some of these issues in further detail. So first of all, scenario one, if the remedial works relate to cladding defects that pose a risk to safety, the Act is quite clear. Qualifying leaseholders will be protected from the removal or replacement of any part of the cladding system that forms the outer wall of an external wall system and is unsafe. So first of all, if it's cladding, if it is falling within the relevant criteria, leases over 21 years, etc., those costs can't be passed down the service charge. Act is quite clear on that. The second scenario is a series of events which may result in the landlord being responsible for the repair costs rather than the cost being charged through the service charge. In particular, there will be no service charge payable for remedying defects to a relevant building where the landlord was responsible for the defect. So what you need to do to make that assessment is look at the position at 14 February 2022, assess whether the landlord developed the building, was responsible for the defect having occurred, whether the landlord was part of a relevant group that may have carried out that development, and whether they may have been in a relevant joint venture with the party that's deemed responsible. And this protection applies to any qualifying premises, and it extends to commercial in addition to residential premises. The next scenario is where the landlord is deemed responsible and can afford to pay. So in this scenario, qualifying leaseholders are protected from paying for measures to remedy defects where the landlord or any person associated with the landlord meets the contribution criteria. And that contribution criteria is assessed again at that relevant date, 14 February 2022. And in order to work out whether the contribution criteria is satisfied, you need to assess the number of relevant buildings owned by the landlord at the relevant assessment date, and you times that by 2 million. So you do relevant property searches, find out what buildings the landlord owns. Are they relevant buildings within that criteria that we looked at earlier? Times that figure by 2 million, and that results in the various calculation to assess whether the landlord may be liable for the service charge liability in place of the leaseholders. And the idea with this principle is that it should be the landlord who pays, the responsible landlord who pays for the remediation costs, rather than the leaseholders who may be the least able to contribute to the costs of repair. And it's also worth checking the various exceptions under the Act, because not all landlords are liable. There are various exceptions for certain landlords who may fall outside the contribution criteria. Scenario 4 concerns a situation where no service charge liability will apply because the lease is a low value. And so the Act again has a contribution criteria. It's assessed at 14 February 2022. The criteria is around leases that are less than £325,000 in Greater London or under £175,000 in all other cases. So if it's a low value lease, Again, the leaseholders will be protected from having to pay a service charge liability for the cladding replacement and fire safety related costs, and the landlord won't be able to pass those costs down to leaseholders. And our fifth scenario concerns a situation where a service charge cap may apply. So if none of the limitations that would prevent the costs of remediation works being charged through the service charge apply, so that could be, for example, where the lease is a low value or the landlord meets the contribution criteria. So in principle, if there's a liability that could be passed down through the service charge, the amount that may be passed down could still be subject to a financial cap. Now, there's a complicated mechanism in the Act to determine when that financial cap applies and how it's to be calculated. And there are annual limits that apply for remediation costs within a 12-month period. And there are also restrictions, which mean that service charge shortfalls can't be recovered from other tenants. So if certain costs can be passed down to some tenants, you can't then recover the balance of those costs in limited circumstances. And in terms of how you assess that cap, you need to look at the value of the costs that can be charged to the qualifying leaseholders, and then assess whether the relevant cap based on the value of the property and whether it's in Greater London or the rest of England may apply. And I've summarised the position in the table below. And we're also seeing these provisions now becoming quite prevalent in real estate transactions. So whenever someone now buys a relevant property, we're seeing that the pre-contract inquiries relating to building safety are being updated. The conveyancers of leasehold property are making inquiries relating to the cost recovery for building safety measures. And those inquiries are being made in order to ascertain whether there's any restrictions on the recoverability of the remediation costs. And the Finance Mortgage Lenders Handbook has also been updated to include requirements relating to the remediation of buildings under the Building Safety Act and the need to identify when the relevant provisions may apply. In our next slide, you'll see that I identify some practical considerations that should be taken into account when deciding whether there's a liability that could be passed down through the service charge in principle, or whether it may be a liability that falls outside these regimes, such that the landlord needs to meet the contribution costs, or whether the leaseholders don't enjoy the protection introduced by the Act. So the first point there is that landlords or management companies will be expected to take reasonable steps from the outset to recover costs through other avenues before including remedial costs in the service charge. So those reasonable costs could be identifying whether there's external funding, such as from the Building Safety Fund, or whether the relevant costs could be claimed from a third party who was responsible for the defect having been identified in the first place. And then, first of all, you need to identify whether or not the works are fire safety related, because it may well be that the works relate to routine maintenance or other issues rather than the costs of remediation schemes. And it's also prudent to investigate who the landlord was at 14 February. So is it the current landlord? Was it a landlord? Has the landlord changed since the 14th of February 2022? And there are some complex provisions within the Act that allow for a subsequent landlord to recover from a responsible landlord at the 14th February assessment date. And it's also worth looking at the service charge liabilities anyway and trying to understand how they operate, who pays what, in what proportion, to what extent do the leases qualify under the Act for the various protection measures, or do they fall outside those measures relating to the costs that need to be passed down. And it's also worth looking at the third-party funding agreements that may be in place. The Building Safety Fund, for example, will expect beneficiaries of funding to look at, other than to the leaseholders for recovery of costs, and that will be written into the agreement. And it's also worth considering whether passing down costs to leaseholders would attract adverse publicity, and that could be from the leaseholders themselves, or generally in the press. So finally, the consideration seems to be that technical advice is required in order to identify why the works are carried out and deemed necessary. So are they items of repair that fall within the provisions of the Act, or are they routine maintenance? So if it's routine maintenance, then they're not afforded, leaseholders aren't afforded the protections that the Act introduced. We need to understand a bit more about whether the works are fire safety related, or are they general issues of wear and tear or routine maintenance. Investigate the landlord position at the relevant qualification date, check the leases, check third-party funding, look to see whether there are any other routes of recovery. So that's all I have time for in this part of the talk. Happy to deal with questions at the end of the presentation. Otherwise, I'm happy to hand over to Alistair Wardle from our guest speaker at Stace, who will update us on construction price inflation and where the market is heading.
Thank you, Barry, and good morning, everyone. So today I'm just going to give you a quick whistle-stop tour of where we are on inflation, and it's typically not a subject that everyone takes a keen interest in, but the events of the last year or so, it seems to be now back in fashion. So just before we move on to construction, I thought I'd give a bit of an overview on the UK economy and where we currently are and what are the wider factors that are driving inflation. We're currently in a period of what's known as stagflation, so that's high inflation coupled with low growth. We're not technically in a recession, but we've seen very little growth so far this year, and this is likely to continue for the rest of this year and possibly longer. The consumer price inflation is at 8.7%. This has fallen slightly from last year, but not as much as hoped due to continuing rises in food price inflation. The Bank of England target rate is 2%. Widespread industrial action is also having a negative impact on the performance of the economy as a whole. Stagflation is quite a rare condition to be in, but it's not unique. We did see a similar set of circumstances in the late 70s and the early 80s. It's quite difficult to break out of without significant investment, and it can last quite a long time. So hence the notion that inflation is quite sticky at the moment. Whilst energy and commodity price pressures have reduced, these have now been replaced by increasing costs of wages and the cost of living crisis. And as a result, the Bank of England has hiked interest rates for the 12th consecutive quarter, and it's now standing at 4.5%, which is its highest level 15 years. Most commentators are expecting interest rates to go up to 5 or even 5.5% by the end of this year. So this graph is just showing how the BCIS thinks these indices are going to perform over the next few years, and you can see that GDP will increase slightly over the foreseeable future with those other indexes dropping. So we're expecting things to start to settle down and balance out. On the next slide, I'll just talk a bit more about construction. So it's a bit of a mixed bag at the moment. On the downside, new work construction output is declining. It's actually contracted 12% in the last quarter, and it's still 3% below pre-pandemic levels. So this has been driven by the poor economic conditions, but also reduced incentives for developers, higher interest rates and high borrowing costs. So alongside this, we've also got the impact of new tighter regulations on fire safety, building performance and sustainability. And these are all impacting on viability of projects by adding costs, but not necessarily any increase in the values. Housing is particularly stressed at the moment. Public sector housing is down 5% and private sector housing 16%. You can see the drop off there on the graph, which is the orange line, which is private housing dropping. On the brighter note, some of the other sectors are performing quite well. So repair and maintenance work will see an exponential growth in the next few years. And this is being driven primarily by the new tighter regulations coming in, which are actually stifling the housing sector. Infrastructure is also forecast to grow for the next few years. And there's some big schemes in the pipeline, Hinkley Point, Thames Tideway Tunnel and HS2, which are all continuing. However, there has been a recent announcement to delay some of these projects, so we may see a drop off with the infrastructure inflation. On the next slide, I just want to talk about the construction drivers. So materials prices have, in the last 12 months, been the main driver behind building cost inflation. However, they have started to stabilize a little bit in the first half of this year. Availability of building products is generally back to the pre-crisis levels of supply now. However, inflation on certain products such as concrete and bricks will continue. Others are leveling off or falling. Energy intensive materials such as steel and plasterboard are continuing to see some price volatility this year, but it's unlikely to be as extreme as we have seen in the past. I think the key point with materials at the moment is that whilst they are settling, they're not actually reducing. So we're still 5% higher than we were a year ago and 40% higher than we were pre-COVID. So you can see on the graph there that the spike that happened last year in materials costs, and it's now dropped back to sort of normal levels of growth. On the other side, you've got the blue line, which is the labour cost inflation. So that's now on the rise, and this will probably be the main driver for building prices in the short term. There's a huge undersupply of skilled labour in the industry, being exacerbated by the high levels of inflation generally in the economy, and this is pushing up wages. Workforce has also shrunk by 180,000 people since pre-pandemic levels. Government is trying to address the issue. It's added some new trades to the shortage occupation list in the budget to try and encourage people back into the market, but we're yet to see whether this is going to have the desired effect. On the next slide, I'll just talk a little bit about what we're seeing out there in terms of contractor appetite and growth. So the construction output is forecast to drop this year, so by about 6% before it starts to grow modestly next year. This chart is showing the market conditions index, which is a measure of the relationship between cost and prices. So this line is showing that costs have been rising faster than prices since 2020, and that means that you've got a downward trend there. But this will stabilize in 2024, and effectively it looks like demand is going to be relatively benign for the foreseeable future. So in terms of contractors and their appetite, again, it's a bit of a mixed picture at the moment. Whilst there is a consensus that contractors are showing more interest to tender projects and including tendering on a single stage basis, there's many of them are still very cautious about overcommitting themselves, trying to secure workload for next year. And the main constraints are financial and labour shortage. I think our experience at the moment is that we are seeing that, and contractors are being very selective in what they bid for and how they bid for it. They do operate on small margins generally, therefore they need to have confidence that projects will go forward, and they need to see it as a real opportunity and worth investing in. I think many of you will probably be aware that there's been some significant casualties recently in the market in terms of insolvencies. There was a 60% increase last year on insolvencies compared to the previous year, and this looks like a trend that's unfortunately going to continue. This will have the effect of obviously shrinking the pool of contractors in the market and affect the capacity to deliver future projects, especially if demand does improve. I think that there's a lot of reports recently about defaults on loans as well, which is highlighting a further strain that contractors are feeling, and does highlight the potential long-term consequences of the challenges that we're facing at the moment. So overall, it's not a great outlook, but whilst we are recovering somewhat with material energy prices reducing, there's still a huge amount of uncertainty out there for clients and contractors. So on the next slide, I'll just talk about where we are on tender price inflation. So where do we think we're going? I think the table on the left shows an extract from the STACE outlook, quarterly outlook that we've recently published. This is showing that we think tender price inflation will increase by 3.5% this year, as for the UK as a whole, and this is in line with the BCIS forecast. London we've set at 4%, and we think this market will see tender prices growing slightly above the UK norm. We're then anticipating it to stay at that level for 2024 before dropping to 3% in 2025. You can see BCIS are a little more bullish in terms of where they think the tender prices are going to go. And on the right-hand side, there's a table there showing the sort of range of forecasts from a selection of industry commentators. For this year, we've got a spread of 2 to 5%. And then for next year, we're looking at between 1.5% and 3.5%, with many thinking that inflation pressures will ease and contractors and clients' risk profiles may become a bit clearer, and that will have the effect of tempering the tender price inflation. I think our view is that whilst there will be some downward pressure on pricing, there's still a very tight labour market and insolvency concerns out there, as well as government regulation impacts and wider global factors that will actually keep this slightly elevated. I think generally most people are predicting there's a consensus that TPI will return to a normal range of 2.5% to 3.5% in 2025. I think finally, just to say that tender price inflation can and often is applied to projects on a broad brush basis. However, it's very, we would have always advised to look at projects on a very specific level and try and come up with your own forecast for each project. They're all different, they're all bespoke, and they will all be subject to different pressures. So on the final slide, just talk a little bit about what we can do to try and navigate the current situation in terms of inflation risk on projects, and how we can ultimately find some common ground between the parties to a contract. As I said, it's important to get considered commercial advice on projects, as they all vary in terms of type, size, complexity of the schemes. There's also less tangible factors such as perceptions of the client and competition, and then just random impacts like the timing of opportunities and how contractors see those fitting into their pipelines. And these will all affect how contractors view a scheme and ultimately how attractive the project is to them. Some mechanisms you can use in contracts to distribute the risk of inflation are price adjustment formulae or fluctuation clauses. These have traditionally been relatively unfashionable, but are making a little bit of a comeback now. However, they are quite complex to set up, and you need to be very careful defining them in the contract so you don't end up with disputes on administering them when you come to the delivery side. Provisional sums and prime cost rates for materials that are volatile can also help reduce the risk premiums that contractors put into contracts. However, most clients will want to see a lump sum price for works, and therefore these measures don't necessarily offer that. Another way of getting around it is to try and pay for materials up front. This has become more commonplace recently, but obviously that carries its own risks in terms of ownership and vesting of those materials, as well as the costs of storage, logistics, and insurances, which ultimately the client will need to bear. We have found that offering shorter payment terms, doing fortnightly valuations, can also help with contractors managing their cash flow risk. The other thing you can do is look to procure differently. We found single stage tenders can work, and we've always held those up as the sort of ideal route to market, as they provide a good level of competition and gives employers certainty of cost and program. A single stage tender from a contracting perspective can be more manageable for them, because they can plan it out in their resource terms. The timelines are often shorter and fixed, and allows them to estimate how much resource they're going to need for those projects. Two-stage tenders have often been the fallback. However, in our experience, they can be abused by contractors, and they do lock up resources for significant periods of time while you're working through that procurement route. So our view is that actually it can be better to just select one contractor and commit to them to try and deliver the project. And if your governance and program allows negotiated contracts with selected contractors, then this can be quite a useful option in challenging market conditions. I think the other thing to say is the importance of going through a rigorous pre-qualification stage on bigger schemes, particularly. Make sure you've got the right pool of bidders, and this also helps give contractors confidence that the project is being well managed, and it should encourage them to be more involved in the scheme once the tenders are released. More collaborative framework agreements are being used as well more widely, and these can be quite useful as well when the market is tight. I think generally just more subtle ways to procure better is just to be honest with contractors, have a transparent bid process, and foster good relationships with them, keeping them informed of the projects as you go. This generally leads, in our experience, to better outcomes. If you limit the number of bidders in the process as well, it does tend to keep their pencils a bit sharper when they're pricing the job. So that concludes my presentation. I think we're going to hand back to Teresa now for the Q&A. Thank you.
Thank you, Alistair, and thank you to all the speakers for your excellent presentations. So now we'll move over to some questions. Can we start with you, Ryland, please? So if an interim payment cycle overvalues the work, can the employer recover this overpayment in a subsequent cycle?
Yeah, thank you, Teresa. It's a very good question. It was partially answered in my presentation, actually, but the longer answer is this, that most standard forms do not allow for the repayment of previous interim overpayments in the express terms. However, if there is an entitlement to be paid on an interim basis and you pay that amount, you then have an entitlement to assess the true value of that valuation. And in circumstances where you can demonstrate that the true value is less than what's been paid, or the notified sum, you can then reclaim in restitution any overpayment. But that's strictly on the basis you have to make the payment of the notified sum first.
Thank you, Ryland. Can I move to Dev then, please? Dev, I really enjoyed your explanation of the Neo Bankside case. This is really interesting. So surely the outcome of the case would have been different if the Neo Bankside apartment block was built after the extension. What do you think about that?
Yeah, that's a good question. And I mean, you would have thought so, right? But in his leading judgment, Lord Leggett actually addressed that issue directly. I suppose because he can foresee situations like that arising in future. And he said it wouldn't have made a difference at all. I suppose the kind of policy reason behind that is the courts don't want to encourage kind of construction races to vitiate what would otherwise be a legitimate nuisance claim. That said, I think practically, I don't think the residents would have bought the claim in the first place, in those circumstances with the viewing gallery already there, given the state of the law that existed at the time. I think most lawyers would have advised against them.
Okay, thanks, Dev. And Barry, in terms of your presentation, so if a landlord isn't responsible for the defect and can't recover from the tenants under the service charge, what are their options? What do they do in that circumstance?
Really good question. So I think it's a case of, first of all, looking to see if there's funding available for the remediation scheme. In the absence of funding, then you need to look at who was responsible for the defect having arisen. So was it, for example, the architect, the engineer who specified the cladding system, who may have designed it? Was it an issue of installation? We're seeing a lot of issues at the moment where the correct cladding system may have been specified, but not installed properly. And that all turns on the expert evidence. So it's a case of looking to see who else may be responsible and obtaining the necessary expert evidence to find out in further detail why these problems have occurred.
So is that what you do, Barry? So if you're trying to work out who is responsible for the defect, do you have to go and get an expert? Is that what you have to do?
So it's driven by the facts. So find out, in more detail what's happened. So why is the defect present? Who's responsible? Was it an issue of design? Was it installation? Was it a combination of both? Was it the product itself that was defective? So you'd want to identify the facts in more detail. An expert is best placed to assist with that. And then when we receive the facts, we can help unpick that and identify what the legal issues are and where legal responsibility lies. But first of all, you need to find out what's happened and why.
Thanks, Barry. And Alistair, in terms of what you described, it's very, very interesting and particularly relevant for the sector at the moment. What will be the impact of the labour crisis in terms of prices and availability?
Well, it's difficult to say, and we're only forecasting, obviously. But I think, obviously, with the labour market being this constrained at the moment, then there's a potential that contractors will struggle to find sufficient labour to deliver projects, and therefore we may see projects being delayed as a result and more claims. I think the RSCS data is saying that contractor confidence is weakening. Lenders have increased rates and pared back their appetite. So contractors are becoming a lot more averse, and the cumulative effect of that is the capacity crawl, which means the tender prices are going to go up despite the fact demand is lower. I think in the short term, what we can do about it is try and be more clever about how we utilise labour, and we might see a move towards more prefabricated and off-site, less labour-intensive and more manufacturing-led solutions to projects. And there's a lot of prefabricated solutions on the market at the moment, and more coming through. So I think that might be something that we see more of, and ultimately a government are going to need to incentivise people to rejoin the market and train more skilled workforce. Yeah,
thank you, Alistair. That makes lots of sense. So I think we've just about run out of time. So thank you so much to all of our speakers, and thank you to you, the audience, for taking the time to join us today. If you did dial into the webinar, please email us at events@wfw.com so that we know that you attended and we can send you a copy of the slides. And thank you so much again for joining us, and we hope to see you next time.